Welcome to Team Tiggio Court TV, where we upload videos every single day.
Yes, ma'am. That's where we were. That's where we were. Since we are on a new day, if you'll raise your right hand, let's please.
Ms. Johnson, I'm Dora Salinas. I'm going to ask you some questions. You and Mr. Johnson, you were married on September 12th of 98. Is that right?
You might move up just as close as you can, but
Oh, no. All right. And you were asked by your attorney about, well, actually, Mr. Johnson was asked about some problems he had with an employer where there maybe were some accusations made against him. Were those accusations made in 1998? Do you remember when those accusations were made? About theft from an employer. Okay, when were those? 2000. So you were just married at that point in time a couple of years, is that right? And none of your children had been born, is that right? And you stayed married to him, is that right? All right. And in fact, you stayed married to him till 2024. Is that true? All right. So you could have divorced him then, but you chose not to. Okay. And when was your first child born? And then you went on to have a second child, is that right? And you went on to have a third child, and you went on to have a fourth child. And in fact, your fourth child was born in 2007, is that right? So there were plenty of good times between you and Mr. Johnson, is that true? Okay. And there were some questions made to him regarding Community Bank and Trust in 2012. You didn't divorce him in 2012, did you? In fact, you stayed married to him for another 12 years. Is that right? All right. And you were asked by Ms. Roberts about your employment history. Where were you employed when you and Mr. Johnson married? What did you do for the credit union? All right. And how long had you worked there? Okay. And did you stop working then, or did you go on to work somewhere else? Okay. And when did you stop working? Okay. When your second child was born, and that was in 2004, is that right? Okay. And how long did you stay home when your second child was born? So you worked as a tech. Where did you work? What hospital? St. Thomas. Were you getting paid then? All right. And from 2014, is it accurate to say that you worked, you either were working and going to school or you were working? Is that right? Okay. And when did you graduate from nursing school? 2000 what? You graduated in 2014. All right. And have you worked as a nurse going forward? I believe you said since 2015. All right. So it's not like you had just re-entered the workforce a year or two before you filed for divorce, did you? You had been working for. Okay. All right. And when did you start working full time? In 2014. Okay. So 10 years prior to the divorce becoming final, you had been working full time. All right. So again, it's not like you just re-entered the workforce. And when did you work for the state of? All right.
let me check. Tap that microphone.
Yeah.
I know, but that we're not working on that. I don't know why that was not working anywhere we can check. I didn't think it said anything. When you get to be my age, it's hard to hear in a building like this.
I understand. That's better. I can hear myself.
I needed to make sure we were picking it up. Thank you.
All right. So Ms. Johnson, it sounds like you worked, you had periods of time where you had children, you took some time off, and then you worked, and then ultimately you went to school, but you were back in the workforce full-time since 2014.
That's correct.
And since 2014, that would have been as a nurse, but you had prior work history with the state of Tennessee, with the credit union and such. Is that correct?
That's correct.
Okay. And what were you earning as a nurse when you and Mr. Johnson separated?
I was actually a travel nurse, was unable to complete the contract with the travel agency. I am not sure of specific amounts.
Well, when you separated, so where were you traveling to as a travel nurse?
Louisiana.
Okay. And were you required to stay in Louisiana?
Yes.
Okay. And had you received any paychecks as a travel nurse?
When we separated,
Yes, ma'am. Or let's just go back 6 months prior to the separation. Were you working as a travel nurse then?
no, it was not.
Okay, where were you working 6 months prior to the
St. Thomas
separation?
Midtown.
St. Thomas. And what were you earning at St. Thomas?
I would say, I don't really know I would have to have that, at least $35 an hour.
Okay. And you're an RN, is that correct?
That's correct.
Which means you're a registered nurse.
Mhm.
Okay. And as a travel nurse, would have you been making more money than you would have?
Yes.
Okay. And then when you were unable to fulfill your contract, where did you go back to work? Or where did you go to work?
I went back to St. Thomas
To
Midtown.
St. Thomas. And do you remember when that was?
May of 2022.
May of 2022. So just the month after you and Mr. Johnson separated.
Yeah, it might have been June 2022. It was I had to have a full-time job.
Okay.
Yeah.
And you separated in April of 2022. Is that right?
That's correct.
Okay. And again, you don't remember what you were earning in May or June of 22, or do you?
No.
Probably at least $35 an hour.
Yes.
And were you working full-time at that point?
In May of 2022, yes, I went back to a full-time job and I'm still currently working that job.
You still work at St. Thomas Midtown?
I do.
What are you earning now?
I have my current pay stub if you would like it.
Well, do you know what it is?
42.
42 an hour?
That's correct.
And do you recall what you were earning in April of 2024 when the divorce became final?
It would be, I do not know.
Would have it been close to $42 an hour?
Yes.
Okay. Now, when you were asked about certain expenses that you paid
Sure.
by Ms. Roberts, you said that you paid the utilities each month after you separated for Mr. Johnson. What did the utilities average?
I paid the electric, the water, the cell phones, the car insurance.
Well, let's talk about
Just
utilities. first.
utilities.
Yes, ma'am.
Utilities would be, you want to average,
Yes, ma'am.
I would say $600 or $700 a month.
$600 or $700. And how much was the car insurance?
The car insurance was around $800 for all 6 of us.
$800 a month.
Yes, ma'am.
Were you paying all 4 girls in car insurance?
Yes, and his as well.
Okay. And who is the insurance with?
Allstate.
And cell phone bill, how much did you pay?
It was around $650. It was for all 6 of us as well, and that's including his.
Did the girls assist with any of their own expenses, such as car insurance or cell phone?
My oldest did pay. She paid around $150 just to help out with, but nobody else. No.
All right, but you didn't pay one house payment, did you, from the date of separation?
I've never paid a house payment.
Well, but sometimes things change after divorce. I mean, would you think that would be an accurate statement?
Sure.
Okay. You were living in the house, is
I
that
was.
right?
I was.
Did you ask Mr. Johnson to leave?
I did.
Okay. So you were living in the house from what date to the time it sold? Would have that been April of 2022?
When we separated?
Yes,
The
ma'am.
children and I lived there.
Okay. All right. And you didn't pay one car payment from that date forward, is that right?
I paid my own car payment, yes.
Okay. Let me back up before I forget. How was your nursing school paid for?
Student loans.
Okay. And ultimately, was there a home equity loan that was taken out against the home?
There was
Okay.
several years ago.
And were your student loans paid off?
No, ma'am.
They weren't paid off.
No, I still have $30,000 in student loans.
All right. So you didn't pay any house payment. You didn't pay one pool payment. Is that right?
That's correct.
Okay. Do you enjoy the pool in
I
the
did.
summer?
I did. I paid to open and close it and the chemicals to go in it.
Okay. Do you even know how much the pool payments were?
Yes, because they started calling me when they were not being paid.
How much were they?
$551.
All right. And do you know how much the house payment was?
I do not.
All right. And the car payment that Mr. Johnson was paying, was that your car at one point in time?
I did drive it, yes.
Okay. And what kind of car was that?
Honda Accord.
Did you pay any of those car payments?
No, I did not.
No. And ultimately, did it get transferred to your daughter? Did she start driving it?
She did when she
Okay.
turned 16.
Okay. And which daughter was that?
Lauren Johnson.
Was there still money owing on the car when that car became her car?
Her father told her it was paid off,
All right. So you're
was
not sure.
It was
Okay.
not, because
Okay.
it was in an accident, so I found out that it was not paid for.
All right. And what happened with that insurance check?
They sent it to me,
Mhm. Whose name was on it?
mine.
Yours?
Yes.
Okay.
Would you like a copy of it?
No, I've not asked for a copy
I
of it.
have-
I'm just
okay.
asking you.
Yeah, my name,
Okay.
yes.
And whose name was on the title?
Troy's.
Okay. And did you sign that title?
Title, no.
No. What happened to the title? Where'd it go?
I'm assuming it was a total loss. The insurance took it. I'm pretty sure they sent the information to him.
Okay. But you never signed that title?
No,
Okay. All right. What'd you do with the insurance check?
I put it into my account.
And how much was the insurance check?
Can I get it? 3,960 maybe? I have it over there.
$3,960. Yeah, if you have it, if I
Can-
can see it. Your Honor, did she get the insurance check to you? Okay, but the car was titled to Troy Johnson, is that right?
That's correct.
Okay, and those proceeds were deposited into your bank account?
That's correct. I notified him that they sent me the check,
Okay,
and they sent him the information to take care of the title.
are you sure about that? I mean, you're presuming, right?
I'm presuming, yes, because
Okay.
the
Okay,
car was totaled.
but you received the benefit of the proceeds, is that right?
That's correct.
Okay, and Mr. Johnson had been paying all the payments, is that right?
That's correct.
Okay, all right, you were separated for how long before you filed for divorce? Almost 18 months?
That's correct.
Okay, and during that time period, Mr. Johnson paid for the uncovered medicals for you and the children, is that right? Or you paid for them through a health savings account that belonged to him, is
Yes,
that
most
right?
of them were set up on reoccurring monthly payments.
Okay, but again, he bore that expense, is that right?
Yeah,
Okay.
yes, it was credit card. They just came out of that account.
That he deposited money into,
Sure.
correct?
Mhm.
You didn't deposit any money
No.
into it, right?
Mhm.
All right, so you agree the house payments that were paid, they were paid by Mr. Johnson, is
That's
that
correct.
right? The pool payments that were paid, they were paid by Mr. Johnson,
Mhm.
okay? The Honda Accord car payments that were paid by Mr. Johnson, is that
Mhm.
correct? And if you would answer maybe yes
Yeah,
or no,
yeah.
it's easier for the court reporter. All right, and the uncovered medicals for you and the children were paid by the HSA account. Is that correct?
Some of them came out of the HSA, yes, I would say.
Where'd the others come out of?
I paid.
You paid some? Do you know
Yes.
how much you paid?
I do not.
Okay. All right. And in fact, Mr. Johnson paid for your health, vision, and dental insurance from the date of separation through October of 2023. Is that right?
He's always had my health insurance.
Do you have health insurance available through work?
Not as a PRN employee.
How long have you been? Are you a PRN employee right now?
No, I'm full-time.
When did you go full-time for St. Thomas?
When I went back in June of 2022.
So you've been full-time since June of 2022 and not PRN, is that right?
Yes, that's correct. And I had health insurance in June of 2022.
In June of 2022. You had your own health
No,
insurance.
I did not. It was through him.
Okay.
He's always had our health insurance.
Okay, but you separated in April of 2022
Mm-hmm.
and you waited to file for divorce until October of 2023, is that right?
Yes.
And Mr. Johnson wasn't served with that divorce complaint until November 21 of 2023, is that right?
I'm unsure of, I think there was some speculation of when he was served, but.
Well, the file would reflect when he was
Okay.
served, is that
Okay.
right?
Yes, sure.
And you never took any action during that time to get your own health insurance?
No, I did not.
All right.
I did get my insurance when I discovered it was canceled. But so yes, I got insurance. It began January of 2024.
Of 24. Okay.
My insurance was canceled. I found out when I went to get a prescription filled. He did not notify me. My insurance was canceled.
You never had any conversation with him at all about insurance?
Health insurance?
Yes,
No.
ma'am. No. Did you just expect that you would be on his health insurance for the next however many, 10 years? 5 years?
No, we had kept things the way it was when we separated. I had his automobile insurance. We had things exactly the way it was when we separated.
Okay. The 401k money that's somewhat in controversy as far as whether or not you should receive a portion of it.
Mhm.
That money was withdrawn more than a year prior to you even filing for divorce. Is that right?
Yes,
Okay.
2022.
In 2022, that's correct. When you were in court in front of the judge on the motion for default, did you notify the judge that had been removed? Oh goodness, 18 months or 2 years prior to you coming in front of the judge?
That was not asked of me.
But you didn't notify the court that, did you?
No.
And you didn't mention that Mr. Johnson would have had to pay taxes on those sums, did you?
No.
And do you disagree that but for Your Honor, the 1099 reflects that taxes were withheld.
I'm sorry.
The 1099 that Mr. Johnson received, and I believe is in evidence, reflect that taxes had been withheld. So when that money was given to him, taxes had already been withheld.
And your question to her was?
Did she testify in court on the date of the default that sum, that Mr. Johnson did not receive that total sum, that he received a lesser amount due to taxes being withheld?
We're talking about what she knew at the time of the default judgment?
Well, I was asking her, when she asked the judge for half of the whole, did she notify the court that there had been taxes withheld?
Overrule the objection. Cross-examination.
All right. Ma'am, did you realize that those proceeds had been taxed?
No,
You didn't know. Do you believe that if those proceeds had in fact been taxed as reflected by the 1099, that you should receive half of the whole? Or do you believe at best you should receive half of what Mr. Johnson received?
the judgment was entered for half of the whole amount.
Well, I understand what the judgment was entered for.
Mhm.
I'm asking you, what do you believe is fair?
The whole amount?
Half of the whole amount,
Mhm.
even though he didn't receive half of the whole amount.
Sure.
Okay. And do you have a 401k?
I do not.
You don't have any retirement
I
whatsoever?
do not.
You could pay into a 401k, is that right?
That is correct.
But you've elected not to.
I have not.
And you could have paid into a 401k since 2014, am I correct?
Through my current employer?
Well, just through whatever employer you had since
Sure, yes.
2014. But you elected not to, is that right?
That's correct.
Okay. When you were in court on the motion for default, you didn't tell the court that you had been living in the house since April of 2022, and that Mr. Johnson had been paying the house payments that were paid. And I'm not asserting that he paid each and every one, but any house payment that was paid, he paid it. Is that right?
That is correct. Yes,
Okay. Did you tell the court that?
that's why he was ordered to continue to pay it.
My question is, did you explicitly tell the court Mr. Johnson had been paying the house payments that had been paid since the date of separation?
No.
Okay.
I'm not sure I understand. I've never paid the house note. He's always paid the house note. So we kept
I
that.
understand
Yeah.
that, but you didn't say, Your Honor, I've been living in the house since 2022. Mr. Johnson has not been, and I haven't paid any house payments, but I'm asking you to order that he keep paying the payments.
There was trouble with the payments, foreclosure, default, things like that, were happening. So
But you didn't tell the court that any payments had been made, that you hadn't made them.
no, I
had you?
didn't, I was not
Okay.
asked that.
Okay. And do you think that it was fair for Mr. Johnson to have to keep paying house payments after the divorce, even though you were the one living in the house?
Joy and I had a verbal agreement that we were going to keep the children in the house until the youngest graduated, so that she could graduate from the
Like-
home she had lived in.
Okay, so is that a yes or is that a no?
What was your?
My question was, do you think that it was fair?
Yes, I do.
You
We
think
were
that
trying to
was
keep
fair?
the children in our home.
You could have paid part of the house payment, couldn't you?
Not at the time. I didn't make the money.
You were making 40-some dollars an hour, is that right?
I also paid all the utilities.
Well, Mr. Johnson also had to pay for another place to live, is that right? You asked him to leave the marital residence, correct?
I did.
Okay, so he had to pay for another place to live or live on the street, is that right?
I don't know that he would have to live on the street.
Well, he had to live somewhere,
That's
correct?
That's correct.
Do you believe he had the right to have an apartment?
He chose that, yes.
He had to pay for it, wouldn't you anticipate?
That's correct.
Okay. You didn't tell the court the day of the default hearing that Mr. Johnson had paid you numerous payments through Venmo, did you?
No,
And you didn't tell the court that Mr. Johnson had paid numerous payments to the children through Venmo, did you?
was not aware of what he paid the children.
Well, you could have prepared for your hearing and had those amounts available to give to the court, is that right?
There was no hearing. We walked up here.
Well, there was
and-
a hearing. You were put under oath,
Okay.
correct?
Well, those questions were not asked of me.
Well, did you tell your attorney that
Yes.
You did?
Mhm.
And you didn't think that it was pertinent to make sure the court knew that Mr. Johnson had paid $6,297.50 in Venmo payments to you and the children?
I was not aware of what he had sent to the children.
Well, you're asking for the back child support judgment and over $26,000
Mhm.
that stand, right?
Yes.
So you don't think that would have been pertinent information to provide to the court when you were in front of the court?
Yes.
All right. And again, you didn't tell the judge that Mr. Johnson had paid over $34,000 in house payments, right?
I was unaware of how much he had paid because I was getting notes on the door, and default letters and foreclosure letters.
Again, that would have been pertinent information for the court to have had, though. Would you agree?
Yes.
And you didn't tell the court that he paid over $11,148 in car payments for a car that you drove and then your daughter drove.
No, I did not. That was my car since he bought it. He bought it for me. He drove a truck that I had paid for.
Okay. But again, you were asking for judgments to
Sure.
be entered against him. Is that right?
Sure. I had asked that Lauren, the Honda Accord be put in my name. We thought at that time it was paid for so that I could insure it for her.
Okay. And you didn't tell the court that he had made over $8,400 in full payments, did you?
No,
Had paid over $5,513 in medical bills, did you?
no,
Sports fees for the children in the amount of $5,157. Did you tell the court
no,
that?
no,
You didn't tell the court that he had paid some fees for your older daughter, even though he wasn't obligated to do so legally, for school, did you?
I were not aware of those.
So do you think, ma'am, that it's fair for Mr. Johnson to not only have paid those amounts, but to have a child support arrearage judgment in the amount of $26,000 plus? And then to have had to bring the house payments current, even though you were the one living there? You
Yes,
think that's fair?
we were trying to keep our children in the home.
When did you put the house on the market?
October 29th.
And when you were divorced in April, is that right? So 6 months it took you to put the house
That's
on the
correct.
market. Why did it take you so long to put the house on the market?
I had multiple people come and look at it. It needed work, multiple things.
What work did you do to the house?
It had to have a water heater. I had to clean the carpets.
You had to do that?
Oh, I didn't have to.
You chose to.
Yes.
Okay. All right. So you were ordered in April to put the house on the market.
Hmm.
Okay. The house was to be sold and the proceeds split. Is that right?
He also had filed the motion to
Set
set
aside.
aside the divorce, so I was unsure of what was going to happen.
So you lived there from April till the house sold in December.
Sold in
Like if
January
you
of
closed in
2025.
January.
Uh-huh.
Okay. So if you put it on the market in October, you had a contract within 60 days. Is that right?
No, our contract close. It was in December.
You put the house on the market in October.
Mhm.
All right. So it sat there from April to October. You're living in it. Mr. Johnson's ordered to pay the payments. You had the benefit of living there an additional 6 months before you even put the house on the market. Is that right?
I was unsure of what was going to happen in the motion to set aside.
Okay. All right. You don't disagree that your husband's name was incorrect on the court papers, do you? His middle name?
No,
What's your husband's middle name?
Bruce,
Bruce. What was in the divorce paperwork? Is it Bryce?
in a couple of places.
Okay. And you don't dispute that the address was wrong, do you?
It was right in a couple of places and wrong in a couple of
Right
places.
in a couple of places and wrong in a couple of places. All right. And you don't dispute that postage was insufficient on at least one occasion, do you?
That's what was provided. I am unsure of. I was not there.
All right. Would you agree that there had been some problems with the name and with the address?
Yes. But I also know that he contacted me on April 27th to let me know he would come get his things on April 28th.
Well, let's talk about that.
Okay.
So, you were in court on April 3rd, right?
That's correct.
So he contacted you on April 27th.
I'm not sure who contacted who first. We had set up a date for him to come get his things.
Testify that it took about 3 weeks for him to get the final decree, right?
I
So
did.
those dates would coincide. That would be
Okay.
accurate, right?
He had 30 days to get his things. Yes.
Well, do you think that it would have been fair for him to like be out of luck if he didn't get the paperwork for 3 weeks? Do you think the 30 days should have started running when he got the paperwork, or should have it started running on April 4th? What would have been fair?
I mean, he knew on April 27th that his things were ready for him to pick up.
Well, didn't you tell him that you hadn't packed up the tools yet?
He had asked for that later. I talked to him April 27th and then April 28th. He said it was going to rain. He would come back later. I never heard from him about the later. His things sat packed up in my home, in our home for months.
Mhm. And when we were in court in October, did you tell us that you would give the code, the realtor code, so he could go get his things?
I'm not sure that we said that we would set up a time. The realtor code, he had called and asked the realtor for that as well.
Okay. Now,
His things were
So-
packed up.
Okay.
So I wanted to make sure that what was packed is what he would what his things he would get.
but, okay, you made sure and you made sure that he would get what you wanted him to get. Is that right?
That is, I had packed his things up, and then when we cleaned the house up and out because we had to move out, his other things that I had and that I moved, I brought to your office.
Well, you had insisted that he not come to the house without a civil assist. Is that right?
I had asked for, yes,
I
and
mean,
so
you were pretty insistent that there be a civil assist. Is that correct?
that's correct.
Okay. And then you were going to meet him at the house with the civil assist. Is that right?
Yes.
But you didn't do that, did you? You
No.
didn't follow your own terms, did you?
I was unable to. I sent my children. I was just trying to get him his things to him.
Why didn't you notify your lawyer so she could notify me?
It was the day before.
Okay. Again, why didn't you notify
I'm
your
pretty
lawyer?
sure it was a weekend. I'm not sure. I think it was over the weekend.
So you just sent his girls.
I sent, yes.
You don't think that would be uncomfortable for your girls and for him?
No,
What
they're
if
his
they're,
children.
you wanted your girls to be in a situation where if something was missing, you want him to ask the girls where it was?
No,
And you had agreed to be there, right? In fact, you had said you would be there. I'll be there, bring a civil assist. And
Okay.
that's what he did, right?
that's correct.
Okay.
He was there.
Okay,
And so were my children for him to get his things on the back porch.
okay. Your children or your children?
Our children.
Okay. All right. So he left.
He
You
didn't,
heard-
he didn't even know his things were on the back
Well-
porch. He left in anger because I wasn't there.
You heard him testify that he felt uncomfortable.
Hmm.
He felt like that it wasn't complying with what the agreement was that Ms. Roberts and I had worked out.
Okay.
All right. So ultimately, you did bring some things to the office and.
That is correct.
And
My children brought them. Our children brought them.
why didn't you bring them?
I was at work.
How many days a week do you work?
3 is full time and I can work up to 5.
Okay. All right. Now, we provided a list last week. You don't have any idea where Mr. Johnson's class ring
I
is?
do not.
You said it was in like the tie rack.
I didn't say that. I believe he did.
What happened to the tie rack?
It was taken down, and when we moved, we had to have the house cleaned out. The
Have you
house
looked-
sold.
Have you looked in the tie rack?
I do not have the tie rack. No,
What happened to the tie
I
rack?
am unsure. There's lots of, I mean, we had to get the house empty.
Did it get thrown away?
I'm not sure.
Okay, the DeWalt ratchet and socket set. Did you buy that?
I do not recall.
Do you heard Mr. Johnson testify that that was a gift. Do you deny that it was a gift to him?
I do not.
And do you not think he should get it if it was a gift to him?
Those things were there at the home. I used some of the tools. I do not know if it was a gift to him.
So you don't know, but he testified it was.
Okay.
So are you opposed to him getting the DeWalt ratchet and socket set?
No,
The drill, the DeWalt 20-volt drill. Did you buy that?
I do not recall who bought that.
Well, do you go to Lowe's, Home Depot,
Sure.
Ace Hardware? Do
Sure.
you buy tools?
I have.
Okay.
I purchased the lawnmower that's on the list.
Okay.
I purchased the weed eater that's on the list.
But you don't know about the drill.
I do not.
What about the saw sale?
The what?
Saw sale? Saw sale. Sawzall.
The DeWalt, I purchased that.
You purchased.
I did.
What does that do? What kind of tool is that? Oh.
It's just a little, when you
I'm not as
put
handy
put
as.
the things off and on.
Okay. And the work light, did you purchase that?
I don't know where that, I'm not sure.
Do you have it?
I don't know.
If you do, are you opposed to Mr. Johnson getting it?
I don't know if I have that. I would not,
Well, my question is if you do, are you opposed to him getting it?
no.
And then the personalized, the Nakona personalized glove and the Nakona black leather.
I do not have any baseball, softball items in my home. I have returned everything that I had to your office.
Okay. And the cast iron skillet that was his grandmother's, I think you said you have a couple of cast irons.
They are mine. I do not know which one. I do not know what he is talking about with that.
All right. If there, and just for clarification, you're not opposed to him getting the orange kayak and paddle.
I do have the orange kayak, his bicycle,
Okay.
and the two
then the
ladders.
ladders.
Yeah.
Where can he get those? How
Uh,
would you like for him to get those?
I guess you can pick them up.
Where can he pick those up from?
I don't have a way to transport them is the only issue. That's why I haven't gotten them to you yet.
Okay.
Um,
Where would you like for him to pick those up from?
I don't. If I can get them to your office, can he get them from you? Okay.
Sure. Okay. All right. And then the other items on the list, which are various hand tools, a 2.5 ton jack. Are you opposed to him getting those things?
I don't have those things, but yeah, everything I have has been returned to him.
All right, let's talk about what you were awarded. You were awarded all the furniture in the house, right? How big was your house?
3,000 square feet?
Okay. And 26 years of marriage,
Mhm.
you'd accumulated a lot of stuff. Would that be accurate?
Yes,
And you were awarded almost all of it. Is that right?
yes.
How many cars were you awarded?
My car and every car for that the children had in their
4
possession.
cars? Is that right?
It probably was my car and all of their cars, so 5.
5 cars.
That's correct.
All right. Mr. Johnson was awarded 1 truck, right?
That's what Mr. Johnson had told me he wanted, the
Was this-
truck.
Okay. All right. You were awarded all the pots and pans,
That's
yes,
correct.
small appliances,
That's correct.
all linen, art, decorations, all of those things. 26 years of accumulation in a 3,000 square foot house. How much money did you receive from the house?
78,000, I believe.
78,000 and some change?
Yeah, I'm not sure of the exact number.
And you've had the benefit of those proceeds since January of 2024? Is that right?
That's incorrect. That would be January.
2025,
Yeah.
sorry, I'm sorry. Okay. I can have just a moment. After the house sold, there was an escrow check that was received, right?
That's correct.
And that would have been for insurance, maybe taxes, is that right?
Yes.
All right. And again, you hadn't paid those payments, had you?
No,
All right. Where's the escrow check?
there was no check. It was direct deposited into my account.
Okay, and how much were those proceeds?
I don't remember. I would have to
You
look.
don't have any idea?
I do not.
They were over $3,000, weren't they?
I, again, would have to look.
Whatever that amount was, those were proceeds that you hadn't paid, correct?
That's correct.
All right. Do you believe Mr. Johnson should be awarded those items? Or that amount, the full of that amount, because you didn't pay it, right?
I did not pay it.
All right. And then ma'am, when you were before the court on April 3rd at the default hearing, the court didn't exactly have the full picture that day, did it?
Full picture of,
Well, the court knew what you were asking for, right?
that's correct.
Okay. But the court didn't know that Mr. Johnson had paid several thousands of dollars. In fact, 4,000 plus
He was not here that day. That's correct.
between the date of separation and the date of the hearing. Is that right? That's all, Your Honor. $94,000.
Yes, I did.
You heard that.
That's correct. Yes, that's correct. I do.
Y'all separated in 2022
That's correct.
after he was soliciting prostitution, correct?
That's
He
correct.
frequented massage parlors and picked up hookers and paid with marital money to satisfy his sexual desires. Is that correct?
I am unsure of how far he went with that, but yes, I have proof that he did solicit a prostitute.
And I asked him on the witness stand the last time when he was testifying in the last hearing before we adjourned about that, and he admitted it.
Yes,
So you felt like you had a legitimate reason for him to leave the marital residence with don't you have 4 girls?
I do have 4 children and yes,
That,
yes.
okay. And did you discuss with them? I know a couple of them are here now today. Did you discuss with them their father's propensity to seek sexual fulfillment outside the marriage?
They were there in the home. Yes, 2 of them were.
And as a result of that, they understood that was going on, and he did not have any type of meaningful relationship with those kids during the time of the separation, did he? Oh, no, ma'am. She raised it. She said, oh, didn't he come and pick up the kids and carry them? And didn't he do this? That was the question that Miss Salinas asked, and I have an opportunity to explore that. Your Honor, exhibit, thinking about the softball, she raised the issue about his $94,000 and how much that was for the children. So I think the door was open.
Well, this is basically rehashing what's already been testified to, but it arguably would come under what fact that some of the questions of what he's being given, what he's asking to be given credit for. So I'm going to overrule the objection. Just limit it to the direct issues about what he's asking credit.
After the separation, who paid for all of the kids' food and clothing?
I did.
Who paid for all of the maintenance to their vehicles, and to their gas, their school fees, going to the movies, going to the ball games, getting their hair done, buying prom dresses, applying for colleges, doing all of that? Who paid for that?
I definitely bought all the prom dresses. Now, a couple of them worked. They would pay their own gas. I paid Lauren's gas until she got a job.
Mhm.
I paid their food unless they buy something themselves, but yes,
Who cooked and cleaned and maintained the house?
I did. I cut the grass at the home.
During the course of your marriage, again, we've gone back and he's talked about the embezzlement issue about 2 years into your marriage, maybe 2 to 3 years into your marriage,
That's
correct? And and after that, there was a check kiting scheme.
That's correct.
And at that point in time, did you and he cease having joint accounts?
We did.
During the course of that, did he always pay the mortgage?
He did.
And did you and he have a discussion at the time of your separation when his marital infidelity or had come up? Was there a discussion that he was going to continue to pay the mortgage?
It was our verbal understanding between the two of us that we would keep the children in the home and that they would graduate in that home. And that was not able to happen.
Okay. But then after it came to the point where you finally filed for divorce some couple of years later after your separation, and that the mortgage wasn't being paid, did you see that that agreement that y'all reached was not going to come to fruition? That you were going to have to sell the house?
Yes,
And in fact, did you go to court and testify that, oh, he promised to pay until my last one graduated, which was just May,
this is
correct?
correct. That's correct.
Instead of doing that, you just went on, we're in financial straits and we need to sell the house.
That's correct.
And did you make attempts to list the house for sale?
Yes,
Within 30 days of the order being entered, when you were represented by Ms. Crabtree, did you get a motion or did she notify you that he had retained counsel to try to set aside the default?
yes,
And again, I know you're not familiar, that default was filed. And are you familiar, did you appear before Judge Suzanne Lockert Mash for the final hearing,
yes,
for the divorce? And again, I took over representation after the motion to set aside was, and did you understand the rotations of the judges so that it was hard to get back? We had to wait until she came back into court.
yes.
At the
And when I
time-
would meet with realtors, they were unsure of the legal because of the motion to set aside, because it did say to sell the house, but they were unsure what
And that was
would come out of the motion to set aside.
between April and when we went to court in October. Did you attempt to try to contact realtors to
Yes.
see what you could do?
Yes,
Were you waiting for the court to determine whether or
Yes.
not there was a valid
what we were going, yes,
order or not? When
Yes.
we came to court, we found out some things, didn't we?
yes,
Did he file bankruptcy?
yes.
Listed the house for the bankruptcy?
Hmm.
And on the date that he brought that, did you discover, did you ever authorize him to sign your name to a secondary? You had the primary mortgage, then what we'll call the pool mortgage. I'll rephrase. I'm sorry. I'm trying to get through some foundational stuff. What type of mortgages at the time of the divorce did you have?
Just the one.
Did you just had one mortgage or did you have two? Primary mortgage and a HELOC or a pool loan?
Yes, there was a pull loan.
Okay, was that a lien against the house?
Yes, there was.
So you had two mortgages.
Mhm.
When we came to court, did you find out there was a third?
I did.
And again, what did we find out when we came to court?
That, there's a new deed of trust on our land that, had my signature forged and notarized on it.
It wasn't good forgery, was it?
No,
Did you ever appear before his aunt? Do you remember what her name was?
her name is Misty, and no, I did not appear
Did you
before
ever
her.
call her and authorize her to notarize your signature?
No, I did not.
We questioned him and you've heard he's invoked his Fifth Amendment privilege against self-incrimination, indicating that he did in fact forge your name.
Yes,
Was that mortgage paid off at the time of the closing to the sum of $20,125.54?
it was.
And again, you saw, and again, I apologize, I don't know the exhibit number, but we produced that in there and there was a statement wherein you weren't responsible for any of that. Is that
That's
correct?
Mhm.
And you're expecting that to be paid back to you.
Yes,
Had he not gotten that, you would have received at least half of that amount back.
that's correct.
Do you know what that amount was used for?
No, I do not.
Did you understand through his testimony that it was rolled back in and the mortgage company made him do that to keep it from going into foreclosure?
That was his statement.
So are you asking to double dip to ask for all the mortgage payments he failed to make? And the lost equity because he didn't make those payments?
Yes,
You're just asking to be paid back according to his forgery and his aunt's complicity in doing that.
Yes,
And you're wanting all that money back. Is that correct?
Yes.
Not just half?
that's correct.
And again, during his testimony, did he produce, I may have missed it, but I want to ask you, did he produce anything showing what his income for 2023 and 2024 was?
He did.
What did he produce as his income for 2024? A W-2?
He did. I do believe he had W-2s.
But again, all of those bank records that he put in, and I'll just a couple of.
Yes,
May I see the exhibits with his bank records?
I mean, I believe you questioned her at length about her income. Correct? I think it's within the scope of cross-examination or redirect rather that
It's the biggest-
she can get into. Let's take our mid-morning recess to let you go through those records. We'll stand in recess for about 15 minutes.
He produced a 1099, a W-2, but he didn't produce any other documents or records. Is that correct?
that's correct.
And we were able, and through a subpoena that Miss Salinas subpoenaed, he produced his bank records during the period from 22 through mid 2024, I believe. Let's see. The last record being January of 2025. And those bank records indicate that he was making more money. There were more deposits than what his paycheck shows. Isn't that correct?
Yes,
Such as in August. When did he quit making? You talked about your agreement that he was going to make the payment until for that. And in you filed for divorce, I believe, in October.
of 23.
When did he quit making the payments on the mortgage? Would that have been sometime in August?
I think it's July. I had no record. I had no way of getting records from the mortgage company. So I
And
do
whose
believe it
name is
was
the mortgage solely in?
his.
So again, in August, his bank records show that he deposited, he had credit deposits of $25,000 plus an additional check of $2,700. So he should have had more than sufficient funds to make the payments for $30,000 or $25,000. The next month, he deposited $16,000 plus an additional payment of $625, excuse me. Following month, his bank records that had been introduced at evidence showed one deposit of $3,339 and then other deposit credits of $11,441. And these records that he produced into court shows that he was making far above what his salary was with where he was working. Isn't that correct?
Yeah.
Now, yeah, this impacts you about the name when Mrs. Crabtree was representing you, that she had an error in the name. And do you recall what that was? Was it just his middle name?
Just his middle name. That's
And
correct.
What is your ex-husband's now middle name?
Bruce,
And what did Miss Salinas put it on there?
Bryce.
So B-R-Y-C-E instead of B-R-U-C-E.
That's correct.
Does he go, what is your husband known by commonly out in the public and in business?
Troy.
So has he ever known as Bruce Johnson or Bryce Johnson?
No,
Again, that was the error in the name. It just went from Bruce to Bryce,
that's correct.
correct? You did receive a copy. even though Miss Crabtree was your attorney at the time, did she provide you with the motion that Miss Salinas filed on his behalf?
Yes,
And again, were you ever able to see the summons? There was some difficulty serving him initially.
yes, that's
I
correct.
think there had to be what's called in the legal terms an alias summons. The sheriff's deputy from Montgomery County tried on at least three occasions. And they could not serve him initially when the divorce was filed back from October 16th and the initial summons. An alias summons was issued in November the 16th, and he was actually served in person on the 21st.
That's correct.
And not only did you rely on the fact that a Montgomery County Sheriff's deputy filed an affidavit with this court or a return summons stating that he physically in person handed your divorce complaint to Troy Bruce Johnson?
Yeah.
And did Mr. Johnson file through his attorney a statement with this court and an affidavit signed by him or a motion signed by him stating he actually did get service on the 21st of November?
I believe it is stated in that motion.
And in that, he purposely stated he didn't take any action because he thought you were supposed to bring him paperwork to sign.
That's correct.
Okay. Did you ever discuss bringing him paperwork for him to sign?
No,
So he had actual service on the 21st of November and he failed to file a responsive pleading, correct?
that's correct.
At that point in time, did you rely on your attorney to go forward on the default?
Yes,
Had you told your attorney, again, who was making the payments on the house?
yes,
Did you have any way at the default to get copies of how much was owed on it?
I had no,
Did you have intentions to sell the house?
yes,
And was that reflected in the court order and what you testified
Yeah.
to?
yes,
And again, at the conclusion of his proof, when he testified, did he put forth any proof about his inability to pay what was court ordered?
no,
He brought his W-4 or W-2 and bank records, correct?
that's correct.
Do you recall him testifying anything about how much he paid in rent, how much he paid in utilities, how much car payment, how much insurance, anything like that on the direct examination prior to him closing his proof? He did not put on any proof about what his expenses or his ability to make the payments that were set forth in the divorce decree, did he?
No,
You were married in 1998, is that correct?
yes,
And was there a period of time that you did not work outside the home?
that is correct.
And how many years was that?
I'm going to say approximately 8 or 9.
8 or 9 years. And were you a homemaker and raising 4 children at home?
Yes,
During that period of time, were your finances such where you were able to do either an IRA or Roth IRA or any other form of retirement?
no, I did not.
And how old were you? You went back and got your nursing degree, started school in 2010.
I started classes in 2005, one class here, they're just prereqs, and then nursing school 2010 and graduated 2014.
And do you recall, how old are you, ma'am, if you don't mind me
I'm
asking?
46.
You're 46.
Yes,
And so about 9 years ago, you went back into the workforce.
yes, correct.
And so you lost a significant amount of time, did you not, in retirement planning?
Yes,
Were you relying on the fact that your husband had a retirement 401k that was going to benefit you when you retired?
yes,
And you expect half of that account?
yes.
Was it discussed with you at any point in time, hey, I'm having financial difficulty, this is what's going on, I need to cash out this 401k?
No, it was not.
And again, looking at those bank records, and if you look at what was put there, he had significant income other than just his employment.
Yes,
Was during the course of y'all's marriage, did he have this, again, as he classifies it, hobby, maybe IRS says it's a business, but did he buy and sell collectibles?
he did. He
Um,
also prepared taxes for people.
okay, and he prepared taxes for people.
Mhm.
And so was that a significant income that he produced during the course of your marriage?
Yes,
In fact, during this embezzlement scheme that he undertook from his previous employer, the Comfort Group,
hmm
wasn't that who it was? How much was he accused of stealing?
I do not recall.
Do you recall that he sold some of the collectibles and satisfied that and paid them back when he was fired?
Yes, we took a U-Haul full of collectibles to Atlanta to sell to pay back the debt.
And so again, these are some of the collectibles. He's been in and out of the house. And has he taken these collectibles
Yes,
throughout the time of your separation?
yes,
Has he ever provided an accounting for those collectibles?
no,
Did you ever ask for one?
no,
So these collectibles that he sold back in sometime in 2001, 2, whenever this thing, you think they were significant value?
sure, yes,
I mean, he had Star Wars collectible signed things. You saw some of the lists
yes,
that he put values on.
yes.
And were those equal to that? And the collectibles, in your estimation, things that he does that, do they typically increase in value as opposed to decrease in value?
Yes,
And your household full of furniture that you've had for years and years and years and raised 4 children on, do you think that the value of that was equal to all of the things that he took out of the house?
the furniture was old. Yeah,
I mean, do you have a solid mahogany queen,
No. no,
dining room table that you imported
no.
from
I had the bed we
France?
had for 19 years.
The stuff you've had for 19 years and raised 4 kids
Yes,
on?
yeah,
And again, when he moved out, did he buy new stuff for his apartment?
he did.
And to your knowledge, did he make room and do anything to where your kids could visit over at his apartment?
It was a 1-bedroom apartment.
And Ms. Salinas asked you that did you tell the court that he was making some of these payments and doing things? In fact, when you went to get your divorce, did you know that he had committed a felony by forging your name and implicated his aunt in a felony by notarizing?
No, I was unaware of that.
Okay. So were there certain things that you didn't know that were happening when you disclosed things to the court? Is that
Yeah,
correct?
yes, the bankruptcy was one as well.
When the car got wrecked,
Yes,
Ms. Salinas was asking you about that. Did you and he talk about the car being wrecked?
we did.
Was he involved in the conversation with the payout on the?
I notified him that they had sent me the check and I had deposited it, and he said, okay. I think my words were, they sent me the remainder. His answer was okay.
Okay. And what did you do with it?
I deposited it.
Now, the escrow check, again, we introduced at the beginning of your testimony, we introduced just a summary sheet of the judgments that he had, and credits given to him was $3,960.63.
That's
Was
it.
that the insurance refund check?
Yes,
And again, you've given him credit on what your synopsis that we handed into the court of that amount. Is
that's
that right?
correct.
And not even just half that amount. You didn't get $7,000 back, did you?
No, I did not.
But again, if that escrow got paid during the year that he wasn't making the payments, is he really entitled to that? Because how that was paid in 2024 was from the proceeds of the forgery that he did. Is that correct?
Yes.
Did you pay, well, excuse me, let me ask you this question first. Was your mortgage, in your mortgage, was the insurance escrowed into the mortgage, or did y'all write a separate check?
No, it was all into the,
So whoever was making the mortgage payment was paying the insurance payment.
that's correct.
And so you got it do you know when it went into effect? Obviously, it was sometime mid-year, but you
Right,
got a refund.
right. That's
And the
correct.
closing was when?
January 7th.
So y'all had prepaid up and until 2025 sometime.
Correct.
And again, do you know you went to court to get the default when? April of
April 2024.
And in March of 2024, he borrowed some $20,000+ under a forged signature. And you heard his testimony. And do you know where that money went? Did it go directly to the mortgage company?
I do not know. That
No.
one.
So some portion of that logic would say would have been paying the escrow.
Possibly, yes.
Now, again, he had 0 days with these. Did he ever spend the night other than what he testified? I think he said 3 occasions. I think he said there was he came to your house
Right.
and not just 3 days,
I believe there was a question of her about credit on the child support calculator, wasn't for days. I don't think that question was asked.
Well, it was he on his testimony, it was asked and on that, and she
Well,
has
let's just clarify. Child support guidelines make it very clear that a day to be given credit for includes a 24-hour period. If that was not the case, he doesn't get credit, as unfair as that seems, because I cannot circumvent or preempt the child support guidelines. He is entitled to a credit for a day when he has the children for a 24-hour period. That is the definition that's given to us under the law, and I don't always agree with that and have argued against it as a lawyer, but it is the law. So we're really kind of getting academic about it. If he didn't have 24 hours periods with the children, then or an overnight, with 24 hours, and we don't have a day to give him credit for.
Do you believe that the testimony that you offered in the proposed division of assets was fair and equitable, given the totality of the circumstances of your separation, affording who was paying what, and the totality of the facts of your divorce?
Yes.
When you discussed it with Ms. Salinas, were you explained about what division of assets was based on?
I'm not sure what you're asking me.
Well, when you filed for divorce, did you understand that the judge had to make a fair and equitable division of assets? You filed for divorce, but you did not, you were working, you did not ask for an alimony payment.
I did not.
And then even though there was fault decided in your final decree, in looking at the final decree, I don't recall that you asked for attorney's fees. You asked for attorney's fees in your complaint, but you did not ask for them at the final hearing.
That's correct.
You simply asked for your health insurance, when your health insurance was canceled, the payment of those bills.
That's correct.
You testified to that on a direct examination
Yes.
on how that came into fruition.
Yes.
And were those reasonable and necessary expenses?
Yes.
To your knowledge, was there ever a discussion between you and him notifying you that he canceled your insurance?
I had to call him. I tried to get prescriptions filled, and that's when I discovered I had no insurance.
And according to the breakdown that he offered in his exhibits that he was submitted into court, it didn't cost any more. He had employee family, correct?
That's correct, and he's had it for
Whether the
years.
family was 4, the girls, or 5, the children and you, there was no savings, correct?
That's correct.
And again, to this date, have you received, pursuant to state law, notification from him or his attorney that your insurance was terminated?
No.
And again, albeit you weren't going through a divorce at the time,
Right.
did you ever get notification from Cobra? Are you familiar with whether or not that, or did have any conversation with him when your insurance was canceled? Were you offered?
No.
And retroactive support, again, he filed a bankruptcy petition.
Where we have the mics that are doing on our sound system, so let's see if we can.
Did you receive correspondence from a Brian Lee Hill, an attorney, about the filing of the bankruptcy?
Would appear to be the case.
Well, Your Honor,
And if he declared bankruptcy, it was dismissed at a later date.
he filed it on the 28th before we went to court on the 30th.
And then it was dismissed.
And then it was dismissed not until December.
Well, but the question, I guess, would become his filing for bankruptcy, other than the issue of credibility and going to the issue of his financial wherewithal, is there any relevance to the fact if it didn't affect the loans or
Judicial admission,
pardon?
the judicial admission,
The one at home, we did not.
I'm sorry, yeah, the judicial admission of what I was getting to the point of the judicial admission of he put what his child support obligation was. And it was not a disputed claim. It was just an admission on his part.
Well, isn't that more properly a question for him rather than her? I mean,
Well,
you can recall.
Can recall him. That's it.
I think. That I'm going to sustain your objection as to it being outside the scope of redirect. I am going to allow Ms. Roberts to involve your client for any purpose that she has, and then we'll deal with any objection. I don't know why that's making that noise.
I don't, I will back up, just set up the answers.
The only reason, Your Honor, if I could, in also the secondary, what I was questioning her on the child support at that point in time, I was getting to the judicial admission. The only other thing that I wanted to put the bankruptcy in is that she received notification of an automatic stay. And that is directly on point with what Ms. Salinas asked about why didn't you sell the house? And why didn't it go forward? So
It would appear
again,
to be relevant on that one limited issue.
right. So again, you received from Brian Hill, who we found later, it was your ex-husband's bankruptcy attorney. Is that correct?
That's correct.
And did you receive notification specifically putting you under a federal court order of what we call an automatic stay?
Yes,
And did you understand that you could take any action in selling any property that was listed in that bankruptcy?
right.
And was the house listed in the bankruptcy?
It was.
We received this, there's not I'm sorry, Ms. Salinas, I'm looking, 10/28 of 2024 is what it says on the date that was filed. I don't have the envelope when it was forwarded. Let me get over to the certificate of service. I don't know that there's one on here. It's been a day since I practiced bankruptcy. The order of dismissal was March 6th of 2024, Henry Hildebrand being the trustee. 25, that's when it was finally dismissed. But when she got the notification, there's not a certificate of service. It just shows that he signed it on October 28th of 2024, but there's not a certificate, and I'm sorry we didn't keep the envelope. So you received this notification. We knew about it when we came to court on the 30th, correct?
That's correct.
Ms. Salinas asked you about how much money you got from the court. The court order said that the proceeds were to be divided, the equity was to be divided equally. Is that correct?
That's correct.
So did you receive the exact same amount that's been deposited with this court pursuant to the October order that's being held, some 78,000 and some change?
That's correct.
Did you have to find a new place to live?
I did.
And was your child still in school
She
at the
was.
time of the sale? So in January of her senior year, you had to relocate.
Correct.
Who had the responsibility of getting the house clean and ready to sell?
He,
At the point, when did you put all of his things outside for him to retrieve?
it was the 7th, December 7th, I do believe he was supposed to come. He came with the cop and the children were there.
But prior in April, you had made arrangements, correct?
Yes, and he did not come and said it was going to rain.
Okay.
I also let him know that day that I wasn't putting his things outside until he let me know so that nothing got damaged. So I didn't hear from him again until court.
Okay. But on April 28th,
He did not.
after he received the final decree, did he contact you and request to be able to come get his things?
No,
There was
the
a-
27th, he called the 28th and said it was going to rain. So he knew he needed to get his things.
Okay.
He had already arranged to pick them up.
So y'all had an arrangement and then he refused to comply.
He said it was going to rain. He would wait.
And then did he ever make another attempt? to come
Not
get him
until court proceedings.
And again, it wasn't until after we were here in October.
That's correct.
And did you try to cooperate and have those things available?
Yes,
And did you think that the division that you made, with you getting your 19-year-old furniture and him getting all of his collectibles and his mountain bikes and his canoes and
That's-
all of those things that was for him and benefited him, did you make any dispute about him getting those?
No.
And you think that that was a fair and equitable division?
yes,
You asking the court pursuant to what we submitted into court, are you asking for 1/2 of the total retirement in the amount of $28,076.36? And that does not include any interest that would have accumulated. That was what he got in 1/2 of what he received.
that's correct.
Or, excuse me, 1/2 of the amount of the balance of the account. Is
That's
that correct?
That's correct.
Your medical expenses, and again, did you produce and have the exact amount of $4,422.38?
Yes,
And he was ordered to pay those.
he was.
He did not.
No,
Did they go into collections?
yes. No, I set up payments on them.
Okay, and you had to pay those, is
I
that
did.
correct?
I
It
did.
didn't damage your credit. You could have let them go into collections and sued for damage to your credit, but you mitigated your damages, did you
Yeah,
not?
yes,
And again, retroactive support, $26,016.
Robert, just so that I can follow along, are you referring to the exhibit that you made of that?
Yes, Your Honor.
Do you happen to recall what the number?
No, Your Honor.
You can get it. I just have to, these are the exhibits, so I have to check.
And it would have been probably 23 or 24, I believe. I think I only produced a few exhibits. And I apologize, I didn't bring my notebook up with my list of exhibits.
Go ahead, I'll find it here in a second.
So again, the retroactive support, $26,016. Did you previously work at the child support receiving, the District Attorney General's Office, Child Support Division?
I did.
And did you know, Miss April Miller?
I did.
And with her assistance, did she run the guidelines for you?
She did.
And did you produce those and give those to Miss Crabtree at the time of the hearing?
Yes,
And were those produced with the income that you had knowledge of?
yes, that's correct.
And calculated that accordingly to the tune of $26,016.
That's correct.
Now, you did not have any information about his insurance, correct?
That's correct.
And he had not had any days with the children other than on occasion when he carried your daughter twice to an overnight ball and one time where you were gone out of town,
That's correct.
and you put 0 days.
That's correct.
Again, earlier I asked you, he got served with the complaint for divorce,
Mhm.
and the complaint for divorce clearly stated that you were asking for child support. At any point in time from the time that he was served in November until the final hearing in April, did he produce any documentation as to the cost of his health insurance?
No,
He had the ability to do that, correct?
yes,
Okay, and during that period of time is when did he also, and I'll recall him on that, sorry. And you think the child support calculations are correct and you're retroactive from the date of the separation of 26,016 is appropriate?
that's correct.
You don't think that there's any issue of manifest injustice for you getting that money?
I am willing to give him the credit for
Well,
those direct payments. that-
Again, I'm going to get to that. but
Okay.
These are the judgments that were done. Is that correct?
Yes, yes,
And so then he didn't pay child support.
no,
You could have filed a contempt petition against him and asked that he be jailed after the divorce was granted. And even after the October hearing, when he dismissed the motion to set aside and your divorce was granted. There's been no request for a modification. He didn't pay any child support. He had a payment due in November.
he paid right when we went to court, right around the court date of October. And then I got another payment around the court date in April, and that's the only child support.
The only payment you've received is through the child support receiving agency.
That's correct.
And they produced documents where he made 3 payments, one on November 31st and 2 on November 11th. Is that correct?
There were
There were 3
three,
payments right before we came
yes,
to court.
yes,
And when you received them on October 31st and then 2 payments on November 11th.
yes, that's correct. That's correct.
Then right before we came to court this time in May,
Yes,
He paid another 3 payments.
it was 23.25, I think.
But, well, that would
Yes.
constitute 3
Yes,
child support
that's correct.
payments.
It was one, yes,
Lump sum total, and you give him credit for that on our worksheet and so reducing the amount that he paid instead of the 26 that he owed you in retroactive support, or excuse me, in current support, you're giving him credit on the current support. So he owes you current support of $6,975. Is that correct?
yes,
And then the 20,125.54 for the criminal act that he undertook.
that's
Is
correct.
that right? Now, you produced, and I didn't give.
Ms. Roberts, let me interrupt you and make sure I'm clear on this. This 20,125.54 is the amount secured by the falsification of a second mortgage, third mortgage,
That was the amount that was paid out at closing.
to pay off the third mortgage.
Yes, sir.
Okay. And you're saying that she should be awarded the entire
Because
$20,000 rather
because
than,
the proof that was submitted, he forged her signature
understand that.
with the statement saying she's not responsible for any of this. If you look at the closing documents.
Look at it.
Mhm. It's not just half, is because had she signed it, she wasn't responsible for any of it. And what we're not doing is double dipping because we didn't come back and ask us, as down on the bottom, we're not asking for any of the missed financial obligations where he was supposed to pay $2,257.39 a month in mortgage payments and $550 on the HELOC. We're not trying to go back and double dip on those and say the equity was reduced because you didn't make those payments.
Right.
Now, you did go back and again, you produced a sheet that I didn't give to them, but you totaled out the payments of monies that he paid for volleyball fees for Lauren, soccer and backpack fees, cross country for Meg, when he paid some grocery bills and different things like that. And you're willing to give him credit for $4,157.50,
Yes,
which is above and beyond what the normal payments where
Yeah.
he benefited your children, basically.
yes,
And you're willing to give him that credit. And then then also you kept the entirety of the refund check for the escrow.
I
for
did.
And that was for insurance. And you were giving him credit for $3,960.63.
Yes,
But you believe that you're entitled to both the 58,000, the 6,900, and the 20,000 minus those 2 payments, those credits.
yes,
Is that correct?
that's the half of it.
No, 58,000 is one half of the Vanguard, correct?
No, 26 is.
Well, one half of the Vanguard, your medical expenses and the retroactive support is the 58,114.74.
Okay, yes,
Current child support from the time that the divorce was granted up and until May of 2025, when your daughter graduated high school,
yes,
is $6,975. He would have owed $11,625. You gave him credit
Yes.
for the 6 payments he made, so the total he owes you for current child support, the new arrearage, if you would, $6,975, correct?
correct.
And then the total amount of the post-judgment, the post-divorce debt of $20,125.54.
Correct.
That totals $85,615.28. Credit for the 41.57 and the 39.
Yes,
There's $78,000 on deposit. So effectively, you're looking to take the majority of that. Is that correct?
yes,
And you believe that's fair enough?
yes,
And you've incurred attorney's fees
yes.
to bring this matter to court, and how much attorney's fees have you paid?
I paid $5,000 already.
Thank you, ma'am.
Mhm.
You testified, sounded like your husband solicited numerous prostitutes. Isn't it true that he never once met up with you?
I know that they had plans and it's in writing. I do not know if he went. I do have the text that he had a plan.
And had there actually maybe been a massage that had been scheduled?
He admitted to what he did. He said he did it. He said that it was a massage parlor that he contacted, but yeah, I mean, I have the apology that he said he went down a rabbit hole he should have never done. He apologized to us, the way he treated us, the way he talked to us.
Remorseful.
He was,
And there was
and very angry. He left that night. The children and I were in fear of our lives.
There was never any evidence that he met and solicited with numerous prostitutes, was there?
Numerous, no, but I do know of one.
No.
And he also said this was his second time in some of the texts, so I'm not sure what he meant by that.
Okay. All right. And you were asked about Mr. Johnson's income from collectibles and those types of things. You hated him trading and having a collectible, kind of a passion for collectibles, didn't you?
Caused lots of lies and deceit, yes.
Well, and it cost a lot of money, right?
I am unsure. He kept all those things a secret from me most of the time.
And isn't it true that he lost more money with collectibles and those types of things than he made money?
No, I would say no.
No. All right. The bank records that your attorney referred to, though, showing money coming in, there were no questions asked about money going out for those collectibles, were there?
No, there were no questions
Okay.
of that.
And you know from your years of being married to Mr. Johnson that there was plenty of money going out to buy new collectibles and to sustain that business. Is that true?
I again, we did not have joint accounts, but I do know he would do multiple PayPal this or multiple avenues of receiving money. So
And he would buy and sell, right?
yes, he did.
So in order to have a clear idea of what was being made, you'd have to know what was being paid as well, right? Is that right?
Yes.
And isn't it true that you and he had been trying to reach an agreement regarding terms of the divorce?
I don't, no.
No, you and he never talked about terms.
I mean, I would say, you know, he did tell me he wanted the truck. He wanted the kids to stay in the home. He agreed with that.
Do you think it would be unreasonable for him to state that he was anticipating that you were going to be sending him papers, whatever those papers might be?
No.
No.
He also at one time said he would drive Uber before I had to move the children.
And are you asking the court to order support that should have been paid from the date the divorce was entered to now?
Yes.
Have you filed anything with the court asking for that?
The support of,
Since the divorce was final in April to now, are you asking the court to award that even though you've never filed any petition?
current child support was ordered.
I understand, but there's been no new filing in regards to support from the date the divorce was final, has there? Well, I just want to be clear that you're, okay. But that's part, I want to make sure that I understand. That's part of what you're asking for in your calculation. Is that right?
Mhm.
Okay.
You wanted to withdraw that so she can file a contempt, or you want to let it just come out of it?
Clarification, Your Honor.
And as often is the case, the response is that we're cutting you a break by not doing that. If you don't like that, then we'll do the other, which is much more severe. So,
No, I understand, Your Honor.
this is, I just point that out for the general clarification of your client that you might want to talk to him about, which is better in his interest.
I will. Your Honor. And then one other thing, if I may approach them.
Complaint for absolute divorce. Yeah. Mhm.
She asked for what?
An award of retroactive support, child support.
Um, it just says adopt the parenting plan. I do believe it was on the parenting plan. The, yeah, I do believe that 26, is that, no, I do believe it's on the parenting plan. No, it just says to adopt the proposed parenting plan, which that's included in.
Marked exhibit.
25.
And then finally, you don't dispute that the address and, the addresses and the names were inconsistent in the original filings with the court.
I do not.
That's all you're.
Roberts. This is the complaint, the last exhibit.
You read what number seven says,
Or general relief.
and also I think it's stipulated number 25 that was served on your then husband. Can you read the top? Notice, what does that say?
Notice of statutory injunction pursuant to TCA 364106D.
And again, if you could, if I can again for the record, read under Tennessee Code Annotated Section 36.106 subsection D, it reflects upon filing this petition for legal separation or and upon personal service of lengthening summons on the respondent or upon waiver of acceptance that this restraining order goes into effect. An injunction restraining and joining both parties from transferring, assigning, borrowing against, concealing, or in any way dissipating or disposing without the consent of the other party or an order of the court of any marital property. Nothing herein is intended to preclude either party from seeking relief, expending money you're restrained from, do you know whether your husband sold any assets during time of separation and continued testimony? He sold and bought stuff on eBay, sold things on eBay with a marital license.
Yes.
Did you see the contempt sanction against that?
No.
Did you get this over with?
Yes.
All right. He's restrained from, borrowing against any marital license, any marital property. Did he borrow against marital property?
Yes.
Did he have your consent?
No.
Thank you.
Thank you, ma'am. You may step down. You may call your next witness. Mr. Johnson, if you'll come back to the stand, please. Stand and raise your right hand and be placed under oath.
Yes.
Mr. Johnson, regardless of whether your middle name being Bruce rather than Bryce, you were served with a complaint for divorce. Is that correct?
Yes, ma'am.
You actually got fiscal service, correct?
Yes, ma'am.
Sheriff's Department came out and handed it to you.
Yes, ma'am.
It was a legible document that you were handed, correct?
Yes, ma'am.
And how far did you go in school, sir? You have a college degree
Yes, ma'am.
and you profess to be an actuarial. You know,
I'm actually in finance, but actuary kind of is what I do in my job.
but you're not an actuarial. You don't have,
I'm not a degree or certified actuary.
you're not
No,
certified.
I measure risk at the
Okay,
insurance.
even though you testify, that's what your job is, but when you said you were an actuarial, that was a misstatement, correct?
Yes.
And
I'm
you
not
did,
Degree. I'm not a degreed
okay,
actuary.
because again, I was Googling while you were previously, and you have to have a certification
Yeah.
and a license to do that.
Yes.
And you don't have that.
Do not. No, I'm
And did I misunderstand your testimony? Did you testify that you in fact were an actuarial?
I don't know if I said I was actually an actuary, but I am not.
Okay, and again,
I
you're, if,
I mitigate risk at the workers' comp insurance level at the state.
I understand that, sir, and I'm just simply calling you back to the witness stand to correct what I had written down that
Oh,
you
okay. No, I
testified
am not an actuary.
as an actuarial.
No, I am not an
I had
actuary.
questioned you about perjury before, and you understand if you did not correct a misstatement, you could be charged with aggravated perjury.
Okay.
And I'm giving you an opportunity to
I
correct
answered.
your
I am
testimony.
not an actuary.
Okay. And in fact, you filed bankruptcy 2 days before we were scheduled to be in court.
Yes, ma'am.
And then you were served with a complaint and you understood it was a legible complaint. The summons was legible to you, the complaint for divorce,
You're talking about before bankruptcy now?
before
Or
bankruptcy.
rolling back? Okay, yes,
Okay.
ma'am.
And did you read it?
Yes, ma'am.
Okay, so you understood you had 30 days from the date that you got it to file a response with the court,
Yes.
correct?
Mhm.
And you elected, being a college educated individual who prepares people's taxes, who works in the finance industry, that mitigates risk, as your testimony was, as you elected and chose and made a informed decision not to respond to the divorce complaint, didn't you?
Well, I was waiting on what Stephanie was going to do.
Waiting on what she was going to do.
Yes, ma'am.
At what point in time did she tell you she was going to bring you documents and when did she tell you specifically, sir, don't worry about the 30 days?
Well, she did not never tell me about the 30 days.
And you never reached out to Miss Crabtree's office, did you?
I did, but she told me she could not give me legal advice.
Okay, so you did reach out
Mhm.
and she told you that she couldn't give you legal advice.
Yes, ma'am.
So you were informed by adverse counsel to you that she couldn't give you legal advice, and did she go in and tell you need to speak to an attorney if
No.
you needed legal advice?
She did not tell me that. She
Okay.
said she couldn't do it for me.
Okay. Did she tell you at any point in time that don't worry about the 30 days?
Miss Crabtree?
Uh-huh.
No, ma'am.
So neither your then wife, now ex-wife, or Ms. Crabtree or any other individual told you to disregard the legal documents that you were handed, did they?
No.
And you made an informed decision not to respond.
To wait, yes, ma'am.
Okay. And then you got the copy of the paperwork, albeit later in April,
Mm.
after the hearing was at the 1st of April. You got the paper sometime,
Of the final decree?
final decree.
Yeah, that's what I received.
Like on maybe April 27th, your ex-wife recalled that you contacted her on the 27th to come pick up your stuff.
Yes, ma'am. I received that because the post lady said didn't have any postage on it. And I happened to be standing at the mailbox
Uh-huh.
bank when she handed it to me, or
Yeah.
I wouldn't have even gotten that.
But you got it.
I did.
Okay. And you opened it up
Mhm.
and you read it.
Mhm.
And you contacted Miss Stephanie Johnson
Did.
and saying, hey, I need to come get my stuff.
Mhm.
Because that's what was spelled out in the decree
Yes, within 10 days.
within 10 days. And so you were like, hey, I just got it. I need to come get it.
Mhm.
And so she said, fine, correct?
Yes.
And Then you called her back and said, never mind, it's gonna rain.
Yes, ma'am, because I had a lot of paper stuff that I didn't want to haul and I didn't have something to haul it over.
And then you never came and asked for it again or made any attempt to get it until after the October.
Well, once I filed the motion to set aside,
Uh-huh.
I didn't want to mess anything up. I didn't want to step on anybody's toes or anything like that. So
Okay.
I just basically just backed off.
At that point in time, after you talked with an attorney,
Yes,
then that's when you said, look, I'm not gonna force the issue because I'm asking this to be set aside.
Yes, ma'am.
And you understand that your attorney asked your wife, well, the court order said to sell the property, and you got to sit in the house from April until it got listed.
Mhm.
Could she not have the same opinion that you had is, hey, there's a motion to set aside, don't know what's happening with it. So I can't sell the house because you're asking to be set aside and relieved of that obligation. Isn't that correct?
Yes, ma'am. But
So you want to hold her to a higher standard than you held yourself?
I just wanted to pay for the house that she was living in.
Okay. But you had all this income coming in.
No, ma'am, I collected money and went out. It was not income. Income's different from collections.
Well, again,
It's a
Okay.
cash-based business. It's not accrual based.
okay, so you're a cash-based business now, and you understand you're under oath.
That's what it is.
You understand that you have just said, we spent countless minutes the last time we were here where you said, no, it's a hobby, and now you've admitted it's a business. So can you pick a horse and ride it?
Well, cash-based business, cash-based hobby, it's cash-based, it's accounting. How about that?
You said you had a cash-based business, correct?
I use cash basis to account for that stuff.
Okay. Well, you use the word
But I
business,
have-
not me.
I have filed it as a business for 2 years. Yes,
Okay.
ma'am.
And did you direct, how and you got served with a complaint, and you understand that you were specifically ordered not to encumber any marital assets. I had your wife read the provision.
Yes, ma'am. If you're talking about my collectibles, they would not be considered assets. They would
No,
be
I'm
considered-
talking about the fact that you forged your wife's name.
I never agreed. I never said I did that.
You never said you did that, but you never said you didn't.
Exactly.
Okay. You've invoked your Fifth Amendment privilege because it would incriminate you.
Yes, and I've been accused of it several times today.
Okay. So are you denying that you did that?
I'm not saying one way or another. I'm
Okay.
invoking my fifth.
Did you have a conversation with your aunt?
My aunt Wynn.
Well, when you borrowed the $20,000.
Did I have a conversation with her?
Mhm.
I went to her house.
How, you went to her house. Did Stephanie ever go to her house, the
No,
house with
no.
you? Did you ever produce paperwork to Stephanie showing that you were getting an additional $20,000?
No, ma'am. And again, was not getting additional money. It was a partial claim that was taking the back payments and putting them to the back of the loan. There was never a cash check, money in my account.
You never discussed that with her, did you?
No, ma'am, I didn't, because I knew she wouldn't sign it.
But you went through and you got that money.
In order to keep them in the house, I did.
Okay. And you never saw her sign that document,
No, ma'am.
and your aunt never saw her sign that document.
No, ma'am.
And when you appeared at your aunt's house to get it notarized, Stephanie's name was already on it.
No, ma'am.
It was,
No.
who signed it?
I'm not gonna say. I'm not gonna say one way or another. I'm invoking my Fifth
But
Amendment.
it
right.
wasn't her.
It was not her.
And 2 days before we came to court on your motion to set aside, you filed a federal bankruptcy petition.
Yes, ma'am.
And you had copies of the amounts that Miss Stephanie said you owed her.
Yes, ma'am. I turned my divorce decree into my attorney.
Okay. Did you disclose the third mortgage on this bankruptcy?
Yes, ma'am.
Sure.
They run my credit.
Who ran your credit?
Mr. Hill,
Okay. I didn't ask what Mr. Gill did.
you just asked me who ran my credit.
No, well, I asked you, did you disclose the third mortgage that you got? And you said,
Mr. Hill.
they ran my credit.
Yes,
And I
ma'am.
said, I didn't ask you that. Did you disclose to Mr. Hill that there was a primary mortgage, there was a HELOC, and then you got a second?
I think at the time,
You didn't, did you?
no, this was 20, this is 24. Are we talking about 24 or 23?
You filed bankruptcy
In 24.
on October 28th of 2024.
Right, okay, yes, ma'am. This should have been
In March of 2024, 1 month before your before the divorce went final,
Right, okay, yes.
you acquired an additional mortgage lien against the real marital property
Yes,
of some $20,000+.
yes, and that was
correct?
included on my bankruptcy.
Okay. And who was that with?
Lakeview Mortgage Services, or Loan Care, maybe it was.
Loan Care LLC, secured for $4,463, secured for $14,207, and secured loan at $367, $352. You have three listed to Loan Care LLC.
That must have been how they broke it down for him then.
What was the HELOC on? Who was it to?
Lafayette Federal Credit Union,
Lafayette,
that was the swimming
to
pool.
the tune of $69,132.
That was a swimming pool.
And again, Ms. Salinas. You understand, federal bankruptcy court submitted it to the court under penalty of perjury, stating that it was correct.
I never went to a federal court
You filed the bankruptcy.
with my attorney.
All of the debts that you owe, correct?
They were the ones that put it all together. Yes, ma'am, I guess I did sign it.
May I approach?
Yes, ma'am, I am, because it was in my divorce decree and I sent it to him. I know exactly what it is.
Asking to change something in alleged to the court. $26,016, because you retroactive support on.
Mhm.
You swore that you owe that.
What?
Now you're saying you don't.
I did, because it was in my divorce decree. I had to put it.
You're-
Mhm.
We're in under oath of bankruptcy petition, and you owe those two, but now you're asking to get out of it. Okay? And he knew you owed these because they were in the deferred.
Yes, yes, ma'am.
Let's turn on down here to where it says Stephanie Johnson.
Mhm.
Not put you, then now you owe to Stephanie Johnson. There were three obligations you owe to Stephanie Johnson. You didn't. One was to work for one half of the 401k. One was for her medical bill, and the third was for retroactive support, correct?
Yes.
But then when you list the Stephanie Johnson in your bankruptcy petition, you said it's an unsecured debt, and you put NA, which is not applicable, so you're not scheduled, you didn't say you owe her any.
Okay.
So you're saying that you didn't swear to the fact that you owed the support, you didn't have public secret divorce decree, but you didn't put the two other names.
No, I did not.
We're only got. Did you commit fraud with bankruptcy court?
Pardon me?
Did you commit fraud with the bankruptcy court?
No, ma'am, I don't
Because you
think so.
knew you owed that money under the final decree.
I left it up. I didn't, my attorney did that. I didn't go backwards and check every single number with it.
So you didn't check to make sure it was right?
I just thought that they would do it right.
Okay.
I'm not a bankruptcy attorney.
And your wife isn't a divorce attorney either, is she?
I'm not sure how that's relevant.
Well, your attorney has asked her, did you go into court and did you testify to this and you testified that? She testified, I relied on my attorney.
Okay, but it's,
You're
that's
on your attorney, right?
right. But she was asked to.
And your testimony was, is that the reason you listed this unsecured, this retroactive support was not that you thought you really owed it,
It was in the decree.
but then what you owed to the decree to Stephanie Johnson, you didn't list. Just a little inconsistency there, sir, don't you think?
You say so?
And you understood that by filing this bankruptcy, your attorney, an automatic stay went into effect.
Yes, ma'am. That
You
was,
understood you stopped the sale of the house.
well, at that time, I didn't know the house was listed.
You didn't know the house was listed in October,
I didn't know the house was listed until I came to court on October the 28th or October the 30th.
October the 30th, 2
30th.
days after you filed
I
bankruptcy.
didn't know the house was listed. I didn't even know they had moved out.
But you knew you had a court date coming up when you filed.
On the 28th?
Well,
Yeah.
you filed on the 2 days before we went. to
Yes, ma'am, because they were fixing to foreclose on.
And that was an attempt, and you were explained that that would stop these proceedings in state court.
Stop which proceedings?
These proceedings, we couldn't go forward on the 30th because you filed bankruptcy and an automatic stay went into effect.
I filed.
And the judge, Judge Lockett Mash, myself, your attorney, all were under, and your wife, all were notified, and we were under an automatic stay. Will you explain that, sir?
I did that to keep the house from being foreclosed on.
Because you weren't making the payments.
I had gotten behind on the payments.
And you had borrowed the 20,000, try to catch it up
Back in March.
back in March, and then you still had made no payments.
Well, I made a couple. I made one in July, and I made 2 or 3 payments after that.
Okay.
But then again, I'm also paying for my house.
And you didn't file to dismiss your case until December 6th
When the
of
house,
2024.
when they said they had a contract on the house, and that it would be when Bronner McCoy said it would be better, that if I'd got that dismissed, I went ahead and told him, hey, I'm not going to go forward with it.
And you didn't lift a hand to go get that house ready for sale, cleaning it up, moving stuff out.
I was not allowed in the house
Well, again, the one time you were allowed to go there, you decided not to pick up your stuff because you didn't want to,
because she wasn't there. It wasn't,
your stuff was there.
it was, but it wasn't on the agreement that we agreed to.
Well, again, nothing further, Your Honor.
Mr. Johnson, I'm going to show you a receipt I made.
A house payment receipt from First Financial Bank where I paid the loan care,
And when was that dated?
July 30th, 2024.
Were you attempting to make payments?
I was doing the best I could. Nobody was helping me with my rent, my electric bill, my water bill, my utilities. I was doing my own stuff and then doing theirs also.
And were you unable to make the payments each and every month?
Yes, once my inventory from my sports cards was depleted, I didn't have any other way to go get money.
And when you filed the bankruptcy petition, was it solely to avoid the house going into foreclosure?
It was just to keep the house from going into foreclosure. Yes.
And you filed the bankruptcy proceeding when? Was it 2 days prior to
I
the
think it was the
October?
28th is when I got the final pages, but I had talked to him, Mr. Hill and Vera, maybe a month before. Because I knew that the house was, I didn't know the house was going up for sale. So I was like, we're going to lose this house if I don't do something. And that was at that time, the only way I knew to be able to keep the house, because I could sell it through the plan.
And if the house, so you filed a chapter 13, is that right?
Yes, ma'am, it was 100% too.
All right, so the house could have been sold if the bankruptcy had continued even?
Yes, ma'am, the court would have just had to approve it.
Okay, all right, but you dismissed the bankruptcy proceeding some 6 weeks after that, is that right?
Yes, ma'am, when I heard that the house had a contract on it, and Bronner told me it would be better if we got the bankruptcy dismissed to get the house sold, and we wouldn't have to go through the federal courts for them to approve I think what I understood, they had to approve the real estate agent, then they had to approve the contract, and then they had to approve the sale, and then they had to approve the disbursement of funds. Well, that was going to be a mess according to Bronner. So I said, well, I'll just dismiss it. If the house is going to sell, it's the only reason I'm here.
And the house did sell?
Yes, ma'am.
Okay, but when you filed, you said you didn't even know that the house had been listed, is that right?
No, ma'am, I didn't know it had been listed. I didn't even know they had moved out.
Okay, all right, but up until October, it had not been listed, is that right?
I'm assuming so. I didn't think it had been listed.
All right, Your Honor, may I have, Johnson, what is your address?
My
Your
current
address?
200 Southampton Place, apartment 1-105, Clarksville, Tennessee, 37040.
Apartment 1-105. 5.
Yes, ma'am.
James Report.
Mhm.
And what address, what apartment?
Apartment 1105
Should it be?
-10. Yes, ma'am, because we have 20 buildings in our unit, each one of them, building 1, building 2. So that apparently went to building 11. Yes, that's not the we, it is incorrect.
And then, sir? Yeah. The address.
Yes, ma'am. 1-105. I actually received a call from Stephanie.
That's already been made it's part of the court file. That's the one. That was my point, is this part of the court file?
It is what it says, it's just correct. Property is on the back of the thing, instead of so that I understand.
Here's the court file, so back, I've already turned it to the back of that summons, shows the sort of.
Yeah.
Yeah.
Yes, ma'am. Yes, ma'am. As a matter of fact, Stephanie had called me late in October and said she had filed for divorce and they had been trying to serve me several times. And I'm like, I'm here. I work from home. I'm here all day. I never go anywhere. Just knock on my door. And I never received that knock. When I told her that the address was 1-105, because that happens a lot. They run all those numbers together and then building 11 gets a lot of my stuff. As soon as I said it's 1-105, then I got the papers.
Then you were served.
Yes, ma'am.
All right. And so you were served on November 21st of 23. And you were asked to read, or Ms. Roberts read into the record, the automatic injunction. Let me ask you, did you drop your wife from your health insurance prior to being served with the divorce complaint?
Yes, ma'am.
Okay. And did you withdraw your 401k money some 18 months prior to the divorce being filed?
Yes, ma'am, in order to make sure the bills got paid.
All right. Then I want to move to the
January 3rd, 2024.
yeah.
I never got that. Okay. Right, I didn't know.
You finally did, in fact.
Yes, ma'am. Yes, ma'am. We have a bank of mailboxes that our mail person comes into and delivers to everybody in West Palm. Yes, ma'am. Apartment 1105. There's no dash. It's apartment 1105. There is no dash after the one, so I wouldn't have received that even if it did have proper postage on it. Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am.
Want them marked as a collective exhibit? You want them
And
separate?
they can be collective. And sir, I believe you said that you received the divorce decree some 3 weeks after it had been entered. Is that right?
Yes, ma'am, because when I got it, I panicked.
Your Honor, that's all I have.
When you were served with this summons, you said you read it. I think you testified to that earlier. Is that right?
Yes, sir.
And did you read this part? It says, to the above named defendant, you are summoned to appear and defend a civil action, parentheses, divorce, filed against you in Chancery Court, Cheatham County, Tennessee. And your defense must be made within 30 days from the date this summons is served upon you. You are further directed to file your defense with the clerk of the court and send a copy to the plaintiff's attorney at the address listed below. In case of your failure to defend this action by the above date, the judgment by default can be rendered against you for the relief demanded in the complaint. Did you read that part?
Yes, sir. I read the whole thing.
So you knew that when you didn't file that answer within 30 days, that a default judgment could be rendered against you.
I knew it could be. At that time I had gone, when I figured out I wasn't going to get, I thought I was gonna get papers kind of telling me what to do, but I never did.
Why did you have that impression?
Cause I'd never done this before. I didn't know what was going on. And then I talked to Holman and Holman and, actually I had to consult with them and they said that I probably had missed the window to file the complaint, but that, I needed to wait and see what I got.
Who told you that?
Holman. They're a men's attorney out of Nashville.
Holman and Holman?
Holman.
That's a law firm?
Yes.
And they told you after you'd been served with a complaint to just wait and see what else you got in the mail?
They said that I would receive something in the mail. And when I got that to, use
Not
that.
exactly a stellar recommendation for a law firm to advise someone who's been served with a complaint to just sit back and do nothing and wait for something else to come in the mail.
I agree.
Because what happened is that you then got a motion for default filed against you as the summons clearly indicated it could. And then the default, you're saying you did not get the default judgment motion.
Yes, sir. I didn't know when that court date was.
All right. Anything further for this witness?
Yeah, I think that's an HOLL. Cordell and Cordell. I'm sorry. Yes. After I got the notice. Yes.
So if you got, in your experience of helping people prepare their taxes, if one of them called you up and said, hey, I got a letter here from the IRS that says I need to call them, what should I do? Would you ever tell them, hey, just sit back and?
No,
wait
I would
and
tell
see
them
you
if they
got
said
something?
call them, I would tell them to call.
You tell them to take some action to defend themselves, right?
Sure.
Stipple. Yes, I'm sorry. Go ahead.
Brought that up. So you got served with a civil summons from Montgomery County and you knew well enough to go into make arrangements to get that taken care of, correct?
Last year, yes.
And when was that?
Last year. It was right before I had filed bankruptcy.
Okay. And then you've still got the DUI pending.
Yes.
And you were told when to appear in court on when did you get the DUI?
Back October the 23rd.
Right when you filed for bankruptcy?
Right.
I mean, we were
28, 5 days after.
5 days after you filed, you got it in October or November of
October.
of 2024.
Yes.
And have you've done what you've been told to in that court?
It was bound over to the grand jury.
Bound over the grand jury. Have you appeared every time you're supposed to appear?
No.
Who's representing you on that?
Brian Edson,
Okay, and if you had to take funds for that?
just $1,000 so far.
Okay.
Anything else? Step down. All right, so we've reached the noon hour. We're gonna break for lunch. How many other witnesses do we have? Other witnesses? All right, I'll hear you after lunch, the argument. Couple of observations about this case before I make my ruling, and one of them is that clearly this is a long-term marriage. Parties were married in 1998. From what I'm seeing in the proof, they have 4 children together. For whatever reason, Mr. Johnson has not been exercising any of his visitation. I know a couple of the children are here with Mrs. Johnson. It's unfortunate that children, even adult children, have to sit through listening to all of the dirty laundry of their parents and all of the reasons why their parents are no longer married. Hopefully, Mr. Johnson, you've got adult children and you can work towards resolving whatever issues there are. To those children that are here, I would simply say you only have one father. Whatever he's done in the past, I'm going to deal with that today. But I hope that you all will all find it in your heart to try to set aside what's happened thus far and to try to come back together as some sort of a family to whatever extent you can. It's not my place to tell you that. I'm just saying it's my experience has been that sometimes when you lose a parent, it makes you more appreciative of the fact that even an imperfect parent is better than no parent at all. So I will now deal with this particular situation. In this case, I'm being asked, I think, to set aside, not necessarily set aside, but to amend a default judgment that I did not enter. If that's not something I normally would agree to do or would do, in this particular case, the motion that was set for hearing on the motion for to set aside the default judgment was set before Judge Turnbow, and then an agreement was entered because of the rotation system that we have. It was going to be 4 months or longer before they could get back in front of the judge who issued the default. So they opted to try to get something done because, if I understood correctly, the house was the main issue trying to get that sold. And for that reason, they agreed to have Judge Turnbow make some decisions in the case. In that order that was entered, the default went down on April the 3rd of 2024. The order that Judge Turnbow put down was not entered until, I think, November the 22nd of 2024. And I never see that date, November 22nd of any year, without thinking about the day Kennedy was assassinated, because I remembered I was in school at that time. In any event, that order set forth the following. It is ordered to judge and decree that the motion to set aside the final decree is and shall be amended to a motion to alter or amend as it relates to the following. And then it set forth 5 different areas that this court was then required to address. One is the amount of money owed to the wife from the husband's retirement account including but not limited to the funds withdrawn by the husband prior to the filing of this divorce matter. And 2, the amount of money owed to the wife mother of retroactive support calculated from the date of the party's separation up to the date of the divorce. The amount shall be determined based upon the requirements of child support guidelines, including but not limited to the party's income, cost of health insurance, the number of days each child resided with the parent. The husband and father may also request credit or offset for any marital debt payments he solely made during this time of separation. Number 3, the amount of medical reimbursement owed by the husband to the wife for the medical expenses the wife incurred after the husband's cancellation of her health insurance. 4, the amount of current child support owed by the father. The amount shall be determined based upon the requirements of the child support guidelines, including but not limited to the party's income, cost of health insurance, the number of days each child resided with each parent. And 5, the husband's ability to pay the monthly mortgage payments as well as the monthly payment due for the installation of the swimming pool at the marital residence. And that order went on to order that the house be sold at a commercially reasonable price, and I think any portion of that would be paid, one half the husband, one half of the sale proceeds would be paid to the clerk and master, and that's what is on deposit. So a Rule 59 motion to alter or amend is a rule that's basically asking the court to come back in and make an adjustment or a change to a prior existing order and to make a different order or in certain respects. My understanding of that rule is that it lies within the discretion of the court to determine whether or not there's a justifiable reason or cause for the alteration of the original order. I have heard the testimony of both parties in this particular case, and it is this court's opinion that I have to base this, at least in part, on the credibility of the parties. Well, when I come to the credibility of the parties, there's really not much of a contest in that particular situation. Unfortunately for Mr. Johnson, the court makes the following findings of issues that directly bear on his credibility regarding the issues that are before the court. One is that he has been accused of and admitted to embezzlement from a prior employer. That is a fundamental act of dishonesty that, as a famous Roman once said, the evil that men do lives after them, but the good is often teared with their bones. Well, what that means is that the bad things that you've done in your life that regard to your honesty will follow you around. And so this embezzlement issue is one that the court has to consider on the issue of your truthfulness and honesty when you testify before the court. The second is that there was a check kiting scheme that you've admitted to, and that check kiting scheme is, again, a basic dishonesty where you're kiting money between bank accounts to represent that you have more money than you do, and that has been admitted by you as well. The issue about the solicitation or involvement with prostitutes or escorts or whatever you want to call it, has been made a big issue. And this court doesn't place a lot of emphasis on that, with the exception of the fact that it does show that there may have been some dissipation of marital assets during the marriage. All of that occurred prior to the filing of divorce, and she did stay with you after those things had come out. I'm not sure if that's a lack of judgment on her part or just the fact that she's made every effort to stay in the marriage for the sake of the children. But the sale of marital items that occurred according to the testimony to help repay the embezzlement or the check kiting scheme, again, would be, in this court's opinion, dissipation of marital assets. Then we have the withdrawal of the 401k. The 401k withdrawal represents an attempt by him to withdraw the what are clearly marital funds, and that may have occurred prior to the filing of the divorce, so that it was not a violation of the statutory injunction, but still it is a withdrawal of that. And I'll deal with that as a withdrawal of the marital asset, which I think without notice to the wife, which again is a fundamental issue. But for the purposes of this hearing, one of the most fundamental problems that I find with Mr. Johnson's credibility is the fact that there is no question in this court's mind that he fraudulently obtained a third mortgage on this property. And he did so by forging or having someone else forge his wife's name and having his aunt then notarize that signature, or whoever the notary was, whether it's his aunt or some other person. That problem puts him, that transaction puts him and all others combined that are involved in that particular situation in legal peril of a criminal jeopardy, because that is basically a fundamental forgery that not only affects Mrs. Johnson, but theoretically affects the lending agencies that occurred to that. A notary public, and I will say this, when my wife was my assistant in my office, and she was notarizing things, and we had some issues because she would not notarize anything unless they sat in front of her and produced proof that she didn't know them or who they were. And that's the process that you're supposed to go through, because the notary public says they are certifying on their oath in their office that they are notarizing the signature of this person, and that they know them or have proof shown to them that that person's identity. So this situation with this third mortgage is, in my opinion, a major impediment to this court giving Mr. Johnson credit for some of the testimony that he's made. His invocation of the Fifth Amendment, as I told him, he has every right to do that. But in a civil case, it carries with it an implication. What you're saying is, I decline to answer the question that has been asked of me on the grounds that my answer would incriminate me, or possibly would incriminate me in criminal conduct. So what do I take from that? I take from that that is basically saying, I'm not going to give you any information that was served to convict me, but I'm going to tell you that my answer would likely incriminate me in criminal conduct. So this court is of the opinion that I can still render an opinion and give fairness to the parties based on what I think the proof has been. Because the dissolution of a divorce and the division of property in a divorce is supposed to be equitable or fair without regard to fault. So while Mr. Johnson clearly has been at fault in a lot of issues, it wouldn't necessarily mean he would get nothing out of the divorce. So I'm going to grant some relief in this situation, and in my discretion, I'm going to make the following findings on these issues that were presented to me. Number one, the amount of money owed to the wife from the husband's retirement account withdrawn, including but not limited to funds withdrawn. According to my calculations and my notes, the Vanguard retirement was withdrawn and it was $28,076.36. Mr. Johnson, through counsel, argues that he should only have to pay her 1/2 after the tax deduction, and this court finds that that argument is not well taken, because clearly it was done without the knowledge of Mrs. Johnson. Had she been advised that he was going to do so, she would have had the opportunity to roll her half of that account into a situation where she would not have to pay any taxes on it. So I find that he owes her $28,076.36 on that, based upon that fact. The amount of money that owed to the wife or mother for retroactive support, calculated from the date of the party separation to the date of the divorce. According to the information that I've been given, the child support that was calculated at least $6,000. Look at all of these notes. I won't want to run through everything I looked at. Not exactly the easiest thing to do while you're trying to eat lunch, to go over all of this information, but he owed child support, calculated child support of $26,016. And I credit that because in the bankruptcy action that he filed, he affirmed under oath, which is a judicial admission, that he owed that $775 a month. And $75 a month is shown to be the retroactive child support, and it is going to be upheld as a retroactive amount. So there is a $26,016 in retroactive support. Mr. Johnson argues that the $94,000 that he has alluded to having paid in support should ought to be, or for family expenses and so forth, ought to be credited to him dollar for dollar and offset any kind of back payment that he owes. He paid house payments of $34,149.96. But of those payments, half of that would have been his responsibility anyway. And so half of it would be attributable to her, that she would have had that obligation. So even in the best case scenario, which I am granting him some relief, I'm ordering that the amount that he would owe her would be the $17,074.98. That would be the credit that he would receive, would be only half of the amount he actually paid. So he gets credit for $17,074.98. And I am going to order that be applied as because there's no other order down that would stop that. Everybody who has children owes support for their children, and they owe it from the date of separation to the present, regardless of whether there's a temporary order down or not. Ms. Salinas but pointed out there was no temporary order and no request for retroactive support, but nonetheless, those children didn't subsist by themselves. Mrs. Johnson was supporting the children and paying all of their expenses, but I'm going to credit that $17,074.98 that he paid on the house payments during the separation against his $26,816 in child support. That leaves a balance of $8,942 that he would have owed in the retroactive support. He canceled their medical insurance, and under that, I'm of the opinion that it's clearly shown she had $4,422.38 that was owed for medical expenses that she could not cover with insurance. He owes her for that because it's cancellation of their medical insurance without notice to her obligates him to pay it. On the Vanguard retirement, I've already stated that he owes her the entire amount of $28,076.36. There was a court-ordered child support obligation of $6,975. That child support order has been affirmed, as I've stated, up to this point, and it will be also an obligation that he owes. And then the fraudulently obtained second mortgage or third mortgage of $20,125.54. I've wrestled with that particular situation because clearly that mortgage was borrowed and then it was paid out of the equity of the situation. And so you can make the argument that she would only be entitled to half of that amount because half of the equity that he borrowed was up to him. But the fraudulently obtaining a mortgage in that particular situation, even if it was to pay off the things that he had let get behind, fraudulently obtaining a mortgage, forging someone's signature is such a reprehensible and illegal action that this court is of the opinion he is not entitled to credit for any of the portions paid to her. So or any of the portion that would normally have been credited to her for that the third mortgage. So in my opinion, he does owe her $20,154. I'm sorry, $20,125.54 for the third mortgage that was taken out fraudulently. That brings to my calculations $68,541.28 that he owes her with all the credits I've given thus far. The statement made by Ms. Roberts, and I may be incorrect, shows that she's crediting him payments of $4,157.50, and the insurance and equitable refund on the sale of the property of $3,960.63, which deducting those two figures leaves him owing her $60,423.15. And that is the judgment of the court that is the amount that she is entitled to out of his portion of the sales price of the proceeds. I have considered, and for the record, we'll go through these family support payments that Mr. Johnson has asked to consider. I've dealt with the Lakeview loan servicing house payment. The car payment, again, there's no court order that required him to pay it, but again, there's no order that says he's entitled to any sort of credit. in addition to the pool payments, I just simply don't find that those are payments, that, you know, there was no agreement that he would be responsible for them. So if he did so, he did so on his own. The medical bills, I've addressed those medical bills that he owed. The medical bills that he may have paid for the children were medical bills he would have owed anyway. The sports payments, I do not find that he is entitled to reimbursement or credit for payments that he made for the minor children and the adult children, or the ones who were adults, for $5,157.60. The insurance, again, through pay stub, if he maintained medical insurance on the minor children and the family and so forth, that's something that I think he's obligated to do anyway. And as a result, I don't think that he is entitled to any sort of credit for that. Neither do I find that the monetary assistance through Venmo are matters that should be credited against those things. There are miscellaneous items ordered for the benefit of the family that, going through them, I simply don't find that those are things. I think it's kind of straining at everything to try to get a little bit of credit, and that comes to Tennessee Tech. I'm glad you were paying for your daughter going to Tennessee Tech, but that's something that's not court ordered. It's not a legal obligation. It may be a moral obligation, but not a legal obligation. And I've reviewed all of those, the other two, the CW pools for maintenance and the pits and turf, and don't find that those items require any sort of adjustment. So I've made that ruling. I will now address the issue of his personal property. Yes, it was ordered under that decree that he had a certain period of time to try to recover his items of personal property. In my opinion, based on the problems with the address, that I'm going to order that he can still try to recover any of those things that I found are entitled to him. I'm not going to go through every one. Clearly, there are things that she says she doesn't have. There's no dispute about his kayak and paddle, or his mountain bike, or his 8-foot and 6-foot Werner ladder, which have been highlighted on this list. Those are things there's no dispute about. His class ring from 1988, if it's found, he gets it. The same thing with his gold ring that's broken. Solid gold cap from his teeth, if it's found and it can be turned over to him, I'll award it to him wherever they may be. If he finds it, or she finds it, and he gets it. I'm awarding him the DeWalt ratchet and socket set, and the drill and impact drill and sawzall, and the work light and leaf blower, all of which I think are those items that he would be particularly inclined to use. The softball equipment, it's my understanding she says she's turned over to him everything that there was in the way of softball equipment. If there's anything else that belongs to him, just give it to him. The antique cast iron skillet passed from Elsie Mae Bradley's estate. I'm assuming that's, and I don't recall from the testimony if that's a family member, but I'm going to go ahead and order that. You get that. Same thing with the 8x10 Star Wars actors. And then these wildlife prints, will order that be done. I am not going to award him the zero-turn lawnmower, because that, in my opinion, is something that she needs for the house, wherever she is. And the weed eater is the same. I will give him the 2.5-ton jack. His softball equipment bag. The Fender guitar was supposedly in the possession of the daughter. He wants to take it away from his daughter, I'll leave it up to him, but I think it should be left with her. Pressure washer. I am not sure which one of them has any use for that, but I'll award that to Mrs. Johnson. And I don't know if I said this, the weed eater needs to stay with the home that she's in. Various hand tools and so forth, I don't find that I can send him over there to let him start going through, picking up every other hand tool. And let me comment on the fact that, as has been pointed out, Mrs. Johnson received the majority of items in the household furniture and furnishing. That's true. But those items have been apparently accumulated during the 27-year marriage. Mr. Johnson, upon their separation a couple of years ago, went out and purchased a items of personal property, household goods, furniture, and furnishings. Those were purchased using marital funds, and technically and theoretically, they are marital property. He has awarded all of those items, and I think that offsets any other issue. I am not going to award attorney's fees in this case because of the fact that there was some issue regarding the addresses on these notices of the motion, and the fact that I am granting some relief on the motion to amend, so therefore I'm not going to award attorney's fees. Anything that I've not addressed? We have stipulated about child support. Further. Others, is adult. If it's found, it turns up to where it wants it. Something you don't know where it is.
Well,
I cannot make a finding that you put in possession of the two when you say you want to go to. I obviously intend to.
Yeah, 30 days now. Seeking contribute some.
I'm not making a finding she has them. I'm simply saying he's awarded them wherever they may be. And that's, obviously if she finds them, then she must turn them over to him. The other items that are there that I have delineated, then he can pick those up within a reasonable time and agreed upon by the board.
Completed the 28,000 and 76.36 for the Vanguard, 4,400. 70,000.
41, 57, 51.
So I have total, 17 cents. And again, I will, as there's 78,000 held part of the court, and I'll be.
Once 30 days, I mean, if they agree to pay it, fine, but I can't order it dispersed until after 30 days from the entry of this order of the law.
Well, and I'll be filing, I have a secondary lawsuit in him on forgery, and I'll be asking for a restraining order, trying to pay me the rest of that money now, on that suit.
Is that the notary public?
The notary, because the notary under her is liable for the dollar for dollar loss on what she has done, so you modify that, I think you have a right to seek that from.
All right. Well, that's my ruling. Thank you.
Thank you, Your Honor.
That brings us to our final case, Butler versus Butler. Sorry, I got everything out of order. Well, you'll be lucky if you don't have food all over it. I did that during my lunch hour trying to.
Yeah, I'll probably, I'll got both of them.
Yeah, I don't know. The lawyers may have it. Mr. Butler is counsel. You're pro se?
Yeah, I'm
Right. Then Ms. Brady, this is for final hearing on the test on the divorce, is that correct? You wish to make any sort of opening statement?
The work from ECS, the ECS, worker, the CPS worker, said that she submitted it directly to, she said the judges approved that. And I'm not really sure where that would have gone. I just wondered if you have it.
I may not find that there is a record of that. The last thing in the file is the answer to the counterclaim, but then part of that is Judge Primbo's order from June of this year.
I'll ask her who she specifically, might be able to get that for me. But anyway, Your Honor, I would, I'll give you my summary of it quickly. It's just that this case has gone around and around, and we are now here. Our most recent order, as you can see, which hasn't been signed yet, but that was announced in court, is that father has supervised visits right now on Thursdays and Sundays from 5 to 7. So we'll be looking at whether we can change to that today, and then trying to separate and assign assets that for a home and a few reimbursements that the wife has that she hasn't paid to maintain that home.
Right. Mr. Butler, you're representing yourself. Do you understand we're here for a final hearing on all those issues?
Sarah, I do understand.
All right. Then Ms. Brady, if you will call your first witness. Ms. Butler, if you'll come around. Well, Ms. Rodriguez is Judge Turnbow's assistant, so it'd have to be forwarded. Ms. Butler, if you'll stand and raise your right hand, let the clerk place you under oath.
All right, Ms. Butler. We don't, like we talked about, you and I have talked about before court, it's 2 o'clock in the afternoon and we're going to try to work through this, but there are some questions that we need to go over about some things that have happened in the last couple of years. And so I'm just going to try to move through those as quickly as we can for the court's sake. Can you describe, or let's start with an incident that happened on December 17th, 2022. Let me say this, please, if you don't mind. You're going to probably have to speak up a little bit because the acoustics in here are not very good. Let me ask you a question really quickly. Let me get this. How long have y'all been married? And what's the date of that marriage? That's fine. What year? And you have a child together? And who is that? And how old is he? Okay, so this is the
You
Chris,
have to speak up. Sure.
And-
Push that down a little bit. Maybe
is
that'll
it
help.
on? Say something into it. Just
I don't
kind of,
think- Our microphones,
all right, well, take it to the rooftops. All right, so this now, so you've been married since 2018. You have a 6-year-old child together. And you live where?
On Dry Creek Road.
And that's a home that you owned together.
Yes.
Okay, so now we're,
let's let him work on it. Go ahead. See if
Say
it works.
something.
There we go.
Hello.
oh, there we go.
Good. Okay.
Okay, so lean into it though, if you don't mind.
Okay.
So this is the December 2022 incident. And you were saying that you were going to go to a community event and it devolved into some arguing. And then what?
So when we get home, I'm exhausted. I'm thinking that I'm just gonna go to bed. And Rob was in Ron's room. I think they were watching TV. And then he came in there and he told me to get out of the bed. And I said no. And so then he went to the garage and got the chainsaw and brought it into the bedroom. He didn't turn it on, but obviously intimidated me with it. And so at that point, we're yelling, we're arguing. It started out with him punching the TV in the bedroom. So he smashed the TV. And then the arguments kept escalating. And a couple different times he held me down on the bed with his hands on my face and he dug his thumbs into my eyeballs, like into my eye sockets, and was spitting in my face over and over again. He did that at least 2 different times. At one point when was out of the bed and we were arguing, he picked me up by my throat and he squeezed it so tight that I felt my trachea compressing, but I did not lose consciousness. We kept arguing. At one point, he threw a full glass of water on me, and at that point, I was so like terrorized and in shock. I thought he had threw a glass of vodka on me because he told me that he was going to burn the witch. And then another time when he was holding me down and he was digging into my eyes and spitting in my face, I was flailing my arms to try to get him off of me. And I must have brushed his face with my fingers. And when I did that, he took his left closed fist and punched me in my right jawline. So I started screaming and crying. And at that point, I heard Ron, and this was probably around midnight. So I ran to check on him and I threw the dog in the room with him and I told him to stay in his room. And we kept arguing. It was in the middle of the night. And finally, I think we were just both exhausted. And he tied a belt around my waist and held it and held me in the bed. So that way he said I couldn't call the police to report what had happened. So the next morning he got up and he went to work and he had hid my phone and my keys, but I found them. Or I didn't find my keys, but I found my phone. So I called my mom, who lives 4 hours away, and she drove here to pick me and Ryan up.
Okay, so Your Honor, can I approach the witness?
You may.
Identify what I've handed you.
That is my right arm with bruises on it where he was holding me and grabbing me.
Okay, and keep just kind of, those are all photos.
Yes.
And when were those photos taken?
These photos were taken, I believe, the day after the incident had occurred.
And do they represent what your body looked like at that time?
Yes.
And who caused those injuries to your body? All right, Your Honor, I'd ask that these be made an exhibit.
Has Mr. Butler seen these?
He has. And then, so that, on that day, you didn't call the police about that incident. But eventually you did call the police. Can you explain how that came to be?
So I had came back home, so the kids could all be together for Christmas. Rob told me that he was gonna go to rehab because he had been drinking that night. But we continued to argue and, I had told him before work, we were both up early for work, that I was gonna take my son to my mom's to get away from him, and he threatened me with child abduction if I did that. So I knew that I needed to get that incident on record. So I went to the sheriff's department, I filed a police report, and they issued a warrant for his arrest.
Your Honor, can I approach the witness?
You know,
Oh.
Can you identify what you have in your hand?
This is the police report.